Hello, we are transmitting live from San Diego, California, in the studios of KPBS on the campus of San Diego State University. Greetings to our distinguished participants in Canada, Mexico, the Dominican Republic, Costa Rica, Panama, Colombia, Ecuador, Venezuela, Peru, Paraguay, Brazil, Bolivia, Argentina, and the United States of America. We would like to thank Canada's annex E2 satellite, the US's Telstar, Mexico's Morelos 2, Panamsat, Brazilsat, and Argentina's Nahuelsat for their satellite linkage services which allow us to reach all of you directly through the wonders of telecommunications. We also acknowledge the initiative of and program support provided by the U.S.-Mexico Conflict Resolution Center at New Mexico State University, located in Las Cruces, and the invaluable leadership of its director, Nancy Oretskin. Today's video conference, entitled Arbitration and Mediation, the Key to Successful International Business, is the second program of a three-part mini-series entitled International Conflict Management and Dispute Resolution. The three programs, the titles of which you can find in your participants' manual, constitute an integrated series of presentations covering the application of alternative dispute resolution techniques to international situations. Today's program is comprised of 2 presentation modules and 2 question and answer sessions. We look forward to your live participation. My name is Richard Page, and I will be your moderator. As you may remember, I am a private attorney with the San Diego law firm of Page, Poland, and Bush, practicing in the areas of business and international law. I am the head of the firm's litigation and international departments. In our last program, we discussed the use of alternative dispute resolution techniques, or ADR, by governments in treaties such as the North American Free Trade Agreement, known as NAFTA, or in Spanish as the TLC. We also discussed the use of ADR as a means of understanding cultural differences in international business. Today's program will introduce the techniques of arbitration and mediation as they have evolved in the United States and Canada, and as they apply in international business. As we heard in the first program, the term alternative dispute resolution in the United States and Canada is referred to by the acronym ADR. The concept arose from businessmen and businesswomen looking for ways to control the soaring costs and unpredictability of litigation. These techniques were referred to as, quote, alternative, close quote, because they focused on resolution outside the courts and formal judicial system. They were an alternative to going to court. The ADR movement is not intended to work against the courts. It is designed to work with the courts. Many of the judges sitting on the federal, state, and provincial benches throughout the United States and Canada consider ADR to be the most effective way to reduce the backlog of cases and to supplement the limited resources which are available to the judiciary. Throughout Latin America, national judicial systems are experimenting with and implementing systems of arbitration and mediation for domestic disputes. The focus of this mini-series is the application of these ADR techniques in the international context and the exploration of ways to coordinate the independent efforts being undertaken throughout the Americas. As the global economy becomes a reality and improved communications bring us into increasing contact with cultures different than our own, there exists one certainty. From this contact will arise disputes, and the mechanism for resolution of these disputes will measure the progress we make toward dealing with our neighbors. It is my pleasure to introduce to you today's guests and expert speakers, David Haigh, who is an attorney who practices commercial advocacy in Calgary, Alberta, Canada, and William K. Slate II, who is the President and Chief Executive Officer of the American Arbitration Association in New York City. A sincere welcome to each of you. Our first presentation will be by Mr. Haigh of the law firm Burnett, Duckworth, and Palmer in Calgary, Alberta, Canada. He obtained his Bachelor's in Honors History from the University of Alberta and his Bachelor of Law degree from the University of Toronto. During his lengthy practice as a commercial advocate, he has gained a variety of experiences in numerous areas of law, as counsel for parties to disputes and as an arbitrator. Mr. Haigh has acted as an arbitrator for the International Chamber of Commerce, known as the ICC or la CCI, and is chairman of the Canadian National Committee of the ICC. He serves on the North American Council for the London Court of International Arbitration and is also commercial arbitration panelist with the British Columbia International Commercial Arbitration Center, among other organizations. He has participated in international symposia on the subject of arbitration and mediation, including a recent presentation in Monterrey, Nuevo León, Mexico, and in Bermuda last month. He is also a Canadian delegate to the NAFTA 2022 committee. Our second presentation module will be given by William K. Slate, who holds a master's degree from the University of Pennsylvania and a Juris Doctor degree from the University of Richmond. He has been the president and chief executive officer of the American Arbitration Association, known as the AAA or la AAA, since April 1994. The American Arbitration Association, a not-for-profit organization founded in 1926, has 36 offices throughout the United States and was the first organization to offer conflict resolution services throughout the world. Mr. Slate is a former director of the United States Federal Court Study Committee. He has given presentations at numerous companies, judicial conferences, and seminars throughout the world. Mr. Slate has had his works published in law magazines, including the American Lawyer, the ABA Journal, Judicature Magazine, the Legal Times of Washington, the Federal Rules Decisions, and the Virginia State Bar News. Before we begin, I would like to ask you gentlemen the following questions. Do you find that organizations are involved in international business and are turning more and more to arbitration, or do they solve most of their differences in court? Mr. Haigh, what are your observations on that?
Well, Dick, I think that as time has gone on, more and more companies doing business outside of their own countries are realizing that arbitration, particularly, is a suitable and reliable and even cost-effective way of dealing with their differences. This is a gradually developing awareness, and of course it depends how far away from home you go before you become motivated to look to alternative means of resolving your disputes. If you're not confident that the national court in some other jurisdiction is going to be a neutral place or an impartial place where you can get your differences sorted out, naturally you're going to be more and more interested in arbitration, particularly as a way of doing that. So my answer to your question would be, yeah, more and more I see companies wanting to investigate and understand and work with this kind of a concept.
Mr. Slate, how do you feel about that?
I agree entirely, Dick. It is very much about creating that level playing field where one has a degree of predictability and also the ability to fashion and tailor a process that is right for a given set of cases or for an individual case. Two statistics that I find compelling in support of the suggestion that more arbitration is being used are the fact that in the U.S., arbitration has grown in the past decade by 500%. And a well-known international accounting firm, Deloitte & Touche, found recently that companies who are engaged in international commerce use arbitration clauses in at least 60% of their contracts. The sum total of those facts suggests to me that arbitration is very much on the rise in international commerce.
Gentlemen, thank you very much. Let us begin now with Module 1, where Mr. Haigh will explain the fundamentals of arbitration.
Thank you. Calgary, as you may know, is in the heart of our oil and gas industry in Western Canada, and so a good deal of what I've been involved in over the years relates to the business and operational aspects of that industry. From when I first began to practice law, I came to learn business people often believe that parties could more readily solve their disputes if it weren't for lawyers and the courts. This notion has inspired people to look for alternatives which may or may not ultimately be effective. One of those alternatives is a very ancient notion which has taken on a fresh impetus in the business communities around the world, especially where commerce is being conducted across national borders. I'm referring, of course, to arbitration. Arbitration is an idea which has been around in one form or another for a very long time, although its modern manifestation has developed significantly in recent years. It is worthwhile considering, therefore, some of the characteristics and qualities of modern international commercial arbitration. That is the object of these remarks. I want to outline to you in very basic terms how I view this subject and to provide you with some information which may lead you beyond these obviously simplified introductory comments. Firstly, let me ask you a very basic question. What is arbitration? Arbitration is usually a private procedure for resolving disputes according to the agreement of the parties to the dispute. Ordinarily, the arbitrator is expected to be an independent and impartial third person who hears and considers the merits of the dispute and renders a final and binding decision called an award. This process is similar to traditional lawsuits because it involves a form of adjudication. However, unlike most courts, in arbitration, the parties get to choose the arbitrator and establish the way in which the arbitration is conducted. If the dispute is fairly simple and does not involve any contentious factual issues, the parties may agree to proceed without a formal hearing by providing the arbitrator with written submissions and documentation only. In more complicated cases, a full hearing and several arbitrators may be more appropriate. The parties create their own process, which is customized to the particular needs of the parties and to the nature of the dispute. In recent years, numerous variations on this simple theme have been developed. Thus, for example, baseball arbitration has developed where each party to a dispute proposes a financial result. The arbitrator is instructed to choose one side or the other, but he is not allowed to compromise or choose between those parties. Other kinds of arbitration call for a specialized expertise in fields such as labor law or construction or certain kinds of agricultural disputes where the arbitrator has specific or technical knowledge. As all of us realize in this era of television and internet, the marketplace of good ideas is constantly alive. No doubt many innovative varieties of arbitration will continue to spring forth from new ground and from various jurisdictions where previously it had not been common. Hopefully all traditions will contribute to this process. I should add my own view as a Canadian lawyer that the common law and civil law traditions are quite compatible in relation to arbitration. Certainly, these two great legal systems have more in common than the small differences which distinguish them. Next, I would ask what role domestic courts have played in the international commercial arbitration process. In my opinion, we cannot discuss arbitration without fully recognizing that it exists within our legal systems, which include our court systems, and not outside or independent of them. Clearly, the laws of individual states, including Canada and the U.S., play a major role in either impeding or facilitating modes of alternative dispute resolution, particularly in the international commercial sphere. Let us look at how this works. The fundamental cornerstone of international arbitration is the agreement between the parties themselves. While the sanctity of private contract has traditionally been upheld by our courts, it is only recently that national law courts have begun consistently to recognize the importance of having parties to private international disputes keep their agreements to arbitrate. As stated by the United States Supreme Court in the case of Mitsubishi Motor Corporation and Solar Chrysler Plymouth, the expansion of American business and industry will hardly be encouraged if, notwithstanding solemn contracts, we insist on that all disputes must be resolved under our law and in our courts. We cannot have world markets and international waters exclusively on our own terms, governed by our laws and resolved in our courts. The same attitude has been adopted and expressed in courts in Canada and throughout the world. Courts have played a key role in the fostering of arbitration and will hopefully continue to do so. In addition, it is important to note that the courts will also continue to have the role of keeping arbitration within its proper boundaries of natural justice and will continue to have the responsibility to protect parties from gross abuses of process. Up to about 10 or 15 years ago, it was common in my part of the world for the judiciary to view arbitration as an alien process from which parties could be rescued on very little pretense. Arbitration was, in those earlier cases, sometimes characterized as being against public policy because it ousted the jurisdiction of the courts. Today, I'm pleased to say the opposite is true. Our judges have now almost universally upheld the validity of agreements to arbitrate and have deterred parties from frivolous attempts to avoid the process by unnecessarily resorting to the courts. Specifically, judicial rulings have impacted three distinct matters relating to arbitration. First, the validity and enforceability of the arbitration agreement. Second, the scope of the arbitration clause and the jurisdiction of the arbitrator. And third, the validity and enforcement of the arbitral award. I propose to examine each of these matters a little more fully. Dealing firstly with the validity and enforceability of the arbitration agreement, what are the main issues? The consent of the parties to submit present and future disputes to arbitration for decision is the foundation of both historical and modern international commercial arbitration. At one time, many civil law states refused to recognize agreements to arbitrate future disputes, and the only type of enforceable arbitration agreements were those made with respect to existing disputes. For example, the Supreme Court of Canada, my country's highest court, decided in 1963 that under Quebec law, the only civil law jurisdiction in Canada, an agreement to submit future disputes to arbitration was void. Since that case, the Quebec Civil Code has been amended by the Quebec legislature to provide for the validity and the enforceability of agreements to arbitrate future disputes. Canadian courts have likewise adopted the concept of the autonomy of the arbitration clause, which means that the arbitration clause stands apart and is severable from a contract that is terminated by performance or is otherwise unenforceable and invalid. As prominent British authors have stated, in essence, a contract which contains an arbitration clause constitutes two separate contracts, one of which is the arbitration clause itself. Today, most modern courts have determined that they do not have discretion to refuse to refer a claim to arbitration where the parties have contracted to arbitrate their disputes. Therefore, even where there are additional parties beyond those who sign the arbitration clause or issues obviously outside the arbitration agreement, the courts tend to say whatever can be arbitrated should be arbitrated. Questions concerning the scope of an arbitration clause give rise to two separate issues. The first relates to public policy limitations upon arbitration as a method of settling disputes. The second relates to the issue of whether the dispute is within the scope of the wording of the clause. The concern, of course, is that if an arbitrator makes a decision on a non-arbitral issue, the resulting award will likely be unenforceable if challenged in the courts. The ability of the arbitrator to determine whether or not he has jurisdiction to deal with the dispute where issues of arbitrability are raised becomes a corollary issue faced by the courts. I will discuss these issues separately. First of all, in terms of public policy. Many countries provide in their legislation that certain types of disputes are not arbitrable. These subjects are generally confined to such matters as securities laws, competition and antitrust laws, matrimonial status, bankruptcy, and certain intellectual property rights such as patents and trademarks. The question for the arbitrator and the courts is whether these restrictions mean that the arbitrator cannot consider issues touching upon these matters, or whether there is some scope for an arbitrator to act without violating the public policy of the state. Next, let me turn to the arbitral clause. The second type of limitation on the scope of arbitration is the language or wording of the arbitration clause itself. The agreement to arbitrate is just that, an agreement. The parties are free to determine the scope of what issues might be arbitrated between them. The sanctity of their agreement must be observed. The primary responsibility for interpreting that agreement and determining the scope of an arbitration is that of the arbitrator himself. Such a decision by an arbitrator may then be reviewed by the courts because it is characterized as a question of law going to the root of the arbitrator's jurisdiction. While many courts have begun to follow a more liberal approach to interpreting the scope of matters covered by such clauses, that has not always been the case. The validity and enforcement of the arbitral awards. What are the main issues? The success of any legal regime for international commercial arbitration depends upon the international effect of the award in some other jurisdiction than the place where the award was made. This, of course, is a principle recognized in the New York Convention and the United Nations Model Law, which I'll discuss a little later. Those instruments provide that an arbitral award, irrespective of the country in which it was made, shall be recognized as binding and upon application in writing to the competent court shall be enforced. The UN-sponsored Model Law provides that recognition or enforcement of an arbitral award may be refused only in a limited set of circumstances, including incapacity, improper notice, where the dispute is outside of the scope of the arbitration clause, where the composition of the arbitral tribunal was not in accordance with the agreement of the parties, where the award is not yet binding on the parties, where the subject matter of the dispute is not capable of settlement by arbitration under the law of the state, or where the recognition of enforcement of the award would be contrary to public policy of the state. These exceptions relate to procedural and non-substantive matters. On the other hand, errors of fact or substantive law may not, generally speaking, be reviewed by the courts. Early indications in Canada, at least, are that our courts will respect the very limited recourse to judicial review contemplated by the model law. Our courts seem inclined to ensure that arbitral awards are valid and to show deference for them and the arbitral process. This is based on the concerns of international comity, respect for the capacities of foreign and transnational tribunals, and sensitivity to the need of the international commercial system for predictability and the resolution of disputes. Next, let me ask, how does international commercial arbitration work? Whose rules do the parties follow? In the world of arbitration, in broad terms, there are two kinds of species. One is ad hoc, and the other is institutional arbitrations. Ad hoc is one way of establishing the rules of arbitration. It is purely where the parties select the arbitrator and create the rules by themselves. If the parties were far-sighted, they may have incorporated their rules into their contract. In many instances, the parties attempt to set the rules after the dispute has begun. This process has obvious potential for trouble right from the very first step, selecting the arbitrator. If the parties cannot agree to that first critical step, the whole process is in jeopardy. Remember that we are dealing with parties who are involved in a dispute and who therefore already have problems agreeing with one another on the issues at hand. This circumstance does not bode well for establishing, by mutual agreement, the rules by which the arbitration will proceed. This does not mean that it cannot be done. In my own experience, for example, if the alternative to not getting the dispute resolved is sufficiently inconvenient, the parties will eventually find a way to do it. Institutional, well-considered, previously published rules, which all parties have agreed will be followed, obviously enhances the whole process. This usually, but not always, means paying a fee to an arbitral institution and submitting to both its rules and its administration. While generally speaking this way of proceeding may initially seem more expensive, it is also more likely to proceed expediently. In addition, institutional arbitration will proceed under the relevant rules even where one of the parties defaults or refuses to cooperate. Although rules, procedures, and institutional bodies have been available for the resolution of private disputes for much of this century, it has only been within the last 15 to 20 years that private parties have begun to make extensive use of available facilities. One of the oldest institutions for the settlement of private party disputes is the International Chamber of Commerce, or ICC. This body was founded in 1919 with a court of arbitration established in 1923. More than half of the cases dealt with under the ICC have occurred in only the last 15 years. Other notable institutions include the American Arbitration Association, or AAA, the Inter-American Commercial Arbitration Commission, or IACAC, IAC, the London Court of International Arbitration, or LCIA. More recently, the Stockholm Chamber of Commerce, or SCC, the Mexico City Chamber of Commerce, the British Columbia International Commercial Arbitration Center, and a host of others have begun to be more active in assisting parties in their disputes. This process of institutionalization with respect to private dispute resolution has also included the creation and adoption by states of international conventions and treaties designed to facilitate the enforcement of arbitral awards and to limit the recourse of parties to judicial appeals in contracting states. The most well-known and the one to date having the greatest impact on the growth of international commercial arbitration is the New York Convention of 1958. The purpose of the convention is to provide national courts with a uniform approach to enforcing arbitral awards by providing only limited procedural grounds for which enforcement may be refused. Although ratification by countries around the world of the New York Convention is not quite universal, it has been quite successful, so much so that it can fairly be said that it is often easier to enforce an arbitral award in a contracting state than it is to enforce a judicial award rendered in another state. The United Nations Commission on International Trade Law, or UNCITRAL, created certain arbitration rules which were adopted by the United Nations General Assembly in 1976. As stated by Redfern, Hunter, and Smith in their text, these UNCITRAL arbitration rules establish a procedural framework which, if properly adhered to, would ensure general international acceptance of the result of the arbitration, particularly under the New York Convention. These rules have attained worldwide significance and are often chosen for administration by agencies such as the ICC or the AAA. Canada and its provinces have been among the first to adopt and follow the UNCITRAL rules. Let me ask you next, what about the institutionalization of international commercial arbitration, and in particular in relation to the North American Free Trade Agreement? As you may remember from the previous program in this series, Chapter 20 of NAFTA deals with the general dispute resolution mechanisms among Canada, Mexico, and the U.S. Chapter 19 deals with disputes concerning anti-dumping and countervailing duty decisions. NAFTA also contains provisions which allow individual investors to have recourse, including arbitration, against the government of one of the other countries in relation to disputes arising out of investment matters. In addition, Article 2022 of NAFTA indicates that each of Canada, Mexico, and the U.S. shall, to the maximum extent possible, encourage and facilitate the use of arbitration and other means of alternative dispute resolution for the settlement of international commercial disputes between private parties in the free trade area. Currently, the 3 NAFTA countries have created an advisory committee which is intended to make recommendations on the best means to achieve their stated objective. Now let me ask, what have these institutions and their rules accomplished for parties involved in an international commercial dispute? Generally speaking, parties seeking to invoke private arbitration procedures in international matters have a wide choice of ready-made rules and procedures to govern the arbitration of their dispute. Numerous institutions stand ready to provide parties with a set of procedural governing rules to determine any critical aspects of arbitration, including how arbitrators will be selected, how many will be selected, whether they must be independent, how the place of arbitration will be selected, if the parties have failed to do so, whether the arbitrators can determine their own jurisdiction, the extent that parties must be given a full opportunity to be heard and present their case, the disclosure and production of documents, the capability to make interim orders, the availability of assistance from the courts, the right to cross-examine witnesses, the appointment and use of experts, the selection of the governing law if the parties have failed to choose, whether the arbitrators must provide written reasons for their decisions, the procedures for making a decision in the event of disagreement between the arbitrators, and the like, to name a few more important factors. These institutions, such as the ICC, the AAA, the LCIA, and others, which are set up nationally or regionally to administer international commercial arbitrations, have done much to make arbitrations a fundamental part of international commercial transactions. In fact, today, most international trade disputes are resolved by arbitration. In addition to the rules and procedures set out, the most other important aspect of what these organizations provide is trained staff, facilities, and registries to ensure that the disputes are resolved expeditiously and efficiently, and that experienced and capable arbitrators are available. Let me turn next to the topic of mediation and briefly discuss the concept of mediation. In recent times, particularly, mediation is a term which has frequently been used in conjunction with arbitration, even though it is a different procedure from arbitration. Generally speaking, mediation is the attempt to resolve differences through the direct communication between the parties, aided and assisted by the services of a neutral third party. Like arbitration, mediation can only proceed with the express consent of the parties. Unlike arbitration, however, mediation does not result in any binding consequences on the parties unless and until they have actually agreed to a result. Thus, the task of the mediator is usually to rely on reason and persuasion to get the parties to come to some common ground. Almost invariably, this involves an element of compromise, and in the case of skilled and determined mediators, the compromise is often achieved by reminding the parties of the unpleasant alternatives that face them should they fail to come to agreement. These alternatives usually include expensive and time-consuming litigation, whether through the courts or through arbitral process. Some mediators as well find it helpful to remind each party of the weaknesses of their case and of the potential for an adverse result. Mediation has been a common technique in many parts of the world in modern times, especially in the fields of labor law and more recently in some countries in the area of domestic relations. Issues such as child custody and access and dividing matrimonial property in common law jurisdictions have been especially suitable for this type of process. In the business community, some very elaborate mediation techniques have been developed. For example, the so-called mini-trial occurs where the parties agree to a private and confidential appearance before a neutral person called an umpire in the United States or a member of the judiciary in Canada. The parties make a summary presentation of their case as if the matter were proceeding to trial. This allows the umpire or judge to hear what each party believes will be its best case, and at the same time to encourage the parties, upon having heard those cases, to resolve their differences in particular ways. Properly authorized decision makers for each party must be present during the process. In the absence of any agreement between the parties, the umpire or judge pronounces a non-binding judgment, which presumably reflects the judgment which a court would give had the parties proceeded to an actual trial. Thus, the parties are encouraged to resolve the matter. Many trials are sometimes referred to as structured mediation. Other forms of mediation rely on the use of trusted third parties, or more frequently in recent times, trained and certified mediators. One matter which is controversial is whether or